was quite blushing with all the over-generous sentiments we expressed about me. And there is only one thing I didn't like. I always tell my PA not to give my date of birth, because I have the weakness of looking younger than I actually am. But that he paid this as respect, and I'm 84, whether you like it or not, there it is. But I'm very happy, it's a privilege. I address students here. I have a certain affinity to Karnataka High Court, particularly to Bangalore. And I may reveal a secret. I have a terrace flat here, to which I escaped from Delhi. There are no law books, music, literature. And that's why I'm a frequent visitor to Bangalore, and I'm very attracted to Bangalore and the people here, whom I find very warm and very friendly. There is one little modification I may make. The title is Rule of Law, a moral imperative for the civilized world. Maybe he got the earlier draft, a moral imperative for the civilized world. That's going to be the title of my talk. Now, the concept of rule of law has different facets and has meant different things to different people at different times. It has evoked sharply divergent reactions. To some legal historians, it is the unqualified human good. Others characterize rule of law, and I quote, as a device that enables the shrewd, the calculating, and the wealthy to manipulate its form to their own advantage. Professor Brian Tamana has described rule of law, and I quote, as an exceedingly elusive notion, giving rise to a rampant divergence of understandings and analogous to the notion of the good in the sense that everyone is for it but have contrasting conceptions about what it is. Well, I suppose this is the reason why the Constitution, the historian Sir Howard Jennings described rule of law as an unruly horse. Now, it will be difficult to define rule of law with scientific precision, but it cannot be dismissed as an elusive notion or as an unruly horse. Rule of law is not a meaningless, ritualistic legal slogan endlessly chanted at seminars and university lectures. Rule of law, in essence, embodies a lofty concept. It denotes commitment to certain principles and values. An essential principle of rule of law is that every executive action, if it is to operate to the prejudice of any person, must have legislative authority to support it. An echo of this principle is found in the ancient case of Entick versus Garrington, decided in 1765. When you have the time, look at the case, it's very interesting. I'll tell you what happened in that case. Two messengers of the king had broken into Entick's house and seized his papers in pursuance of warrants issued by the Secretary of State. In the action brought by Entick for trespass, the Secretary of State conceded that no specific legal authority, either in the common law or in statute, permitted him to issue the warrants. His defense was that the warrants were necessary in order to protect the interests of the state, and that similar warrants had been used in the past without question. These arguments were rejected by the court. And in a seminal ruling, the court held that government needed specific legal authority to arrest people, and claims of state necessity be insufficient. Very important, has a relevance even now. Since the general warrants were legal and void, the king's messengers could be sued for trespass, and this principle has generally been followed in Great Britain. Same principle was reiterated in 1931 by Lord Atkin in the celebrated judgment of the Privy Council in the case of Esugba Elko, in the case arising from Nigeria. The Privy Council declared that no member of the executive can interfere with the liberty or property of a British subject except on the condition that he can support the legality of his action before a court of justice. Although there is no mention of the rule of law in the Privy Council opinion, the seeds for the future development of the doctrine of the rule of law were laid in the judgment. The vital importance of rule of law in safeguarding the fundamental liberties of person is well brought out in an anecdote attributed to Voltaire, maybe apocryphal, but it's a good anecdote. You know, Voltaire, the great French thinker, he had offended many authorities, the church and other conventional thinkers. He was imprisoned for a piece of writing he did not write, whose author he did not know, and whose sentiments he did not share. His imprisonment was an account of the arbitrary whim and caprice of the ruling authorities in France. When he escaped and came to London, his first observation was, "Here I breathe the air of freedom, because in this country men are ruled by law, not by whim and caprice, in other words, not by arbitrary rule." Thus, when John Adams used the historic phrase, "a government of law and not of men," he was not indulging in rhetorical flourish. He was emphasizing that law containing rules of general application and not individual whimsicality should govern the conduct and affairs of the people. Now I'll tell you something interesting. Have you read the play Men for All Seasons? That's by Robert Bolt. It portrays the life of Sir Thomas More. In this play, Men for All Seasons, it pertains to an incident when Sir Thomas More was urged by his daughter, Margaret, and his son-in-law, Roper, to arrest a man whom they regarded as evil. More replied, "There is no law against that." Roper said, "There is God's law." More then said, "Then God can arrest him. I know what's legal, not what's right, and I will stick to what is legal. I am not God. The currents and eddies of right and wrong which you find such plain sailing, I cannot navigate. I am not a warrior." Roper would not be appeased, and he pressed on, and he leveled the charge that More would even give the devil his due. And More said, "Yes, what would you do? Cut a bridge road through the law to get even after the devil?" Roper retorted, "I'd cut down every law in England to do that." And that prompted More to say, "Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The country is planted thick with laws from coast to coast, men's laws, not God's. And if you cut them down, do you really think you can stand upright in the winds that would blow them? Yes, I'd give the devil the benefit of law for my own safety's sake." Now this is the play. The interesting thing is the Australian ambassador to US persuaded the great Judge Felix Frankfurter of the US Supreme Court to see the play. And Sir Howard Beale, it is said that when More counters Roper with the statements which I just made, Frankfurter could not help contain himself and kept whispering in the dark, "That is the point, that is the point, that is the point." And actually that is indeed the essential message and rationale of the rule of law. Alas, it is constantly disregarded. Now, I want to emphasize one thing. There is nothing northern or southern or western or eastern about rule of law. Rule of law has a global reach and dimension. Rule of law symbolizes the quest of civilized democratic societies to combine that degree of liberty without which law is tyranny with that degree of law without which liberty becomes license. In the words of our great Justice Vivian Bose of our Supreme Court, whom I regard as one of the greatest judges, he said, "Rule of law is the heritage of all mankind because its underlying rationale is belief in the human rights and human dignity of all individuals everywhere in the world." Rule of law provides a potent antidote to executive lawlessness. Can I have some water? It is a salutary reminder that wherever law ends, tyranny begins. Thanks to the prevalence of rule of law, no administrator or officer can arrest or detain a person unless there is legislative authority for such action. Again, a police commissioner or any other public functionary cannot ban a meeting or the staging of a play or the screening of a movie by passing a departmental order or circular which is not backed by law. Likewise, no person can be deprived of his property without the authority of law. Rule of law ensures certainty and predictability as opposed to whimsicality and arbitrariness, so that people are able to regulate their behavior according to a published standard against which to measure and judge the legality of official action. Experience testifies that absence of rule of law leads to executive high-handedness and arbitrariness and emergence of what we call police raj. Rule of law runs like a golden thread in our Constitution. Article 14 states, "The state shall not deny to any person equality before the law or the equal protection of the laws." As you know, no fundamental right in the Indian Constitution is absolute. It can be restricted on certain specified heads. But the primary requirement is that the restriction must be imposed by law. It cannot be by departmental instructions or non-statutory circulars. And the whole question is, so therefore, no tax can be levied or collected except by authority of law. That's Article 265. And even the Article 301, 300A, stipulates that no person can be deprived of his property save by authority of law. Now you have all heard and read about the unique judgment of our Supreme Court in Keshav and Bharti. In that, it's a unique judgment really, and so far the only High Court, only Supreme Court which has followed this is the Bangladesh Supreme Court. What did the Supreme Court hold, amongst other things, in Keshav and Bharti? That even a constitutional amendment can be struck down as unconstitutional if it abrogated any essential features of the Constitution. And it is significant that the court considers rule of law as one of the essential features of the Constitution. In a subsequent 9-bench judgment in Boydo's case in January 2007, the rule of law was regarded again as part of the basic structure of the Constitution. Consequently, rule of law cannot be abolished, even by a constitutional amendment. This manifests the high status according to rule of law in Indian constitutional jurisprudence. And mind you, that's not merely in theory. In practice, our Supreme Court has vigorously enforced the rule of law. A remarkable instance is the invalidation of a constitutional amendment by the Supreme Court in the judgment in the case of Indira Gandhi versus Raj Narayan, delivered on 17th November 1975. Now let me give you a few background facts. Mrs. Gandhi's election petition was challenged by her political rival, the feisty Raj Narayan, in the Allahabad High Court on the ground of commission of certain alleged electoral malpractices. The High Court invalidated Mrs. Gandhi's election on that ground. Appeal was preferred to the Supreme Court by Mrs. Gandhi in order to get over the High Court judgment. Now the interesting thing is, by the Constitution 39th Amendment, certain clauses are added. Clause 4 exempted the disputed election of Prime Minister Indira Gandhi from the restraints of all election laws and declared the election valid, notwithstanding any judgment of any court. Now see what Clause 5 did. Clause 5 further ordained that any appeal pending before the Supreme Court shall be disposed of on the assumption that the findings contained in the judgment of the High Court under appeal never had any existence in the eye of law, and that the election declared void by the judgment of the High Court shall continue to be valid in all respects. But it's incredible now that such clauses should have been introduced in our Constitution in the Democratic Republic of India. But regrettably, during the period of emergency, democracy has suffered a temporary demise. These provisions, which are a state of the Supreme Court, were described by Justice Substitute of the Supreme Court as calculated to damage or destroy the rule of law, and as the very negation of the rule of law. But, however, the appeal of Mrs. Gandhi was allowed on other grounds. Our Supreme Court has ruled in more than one case that any executive action prejudicial to a person must have a sanction of law. There are several instances. Let me give a couple of them. One was a case before the Supreme Court which came from Punjab, whose police officials are known for the no-nonsense approach. What happened that possibly thrown out some people from government premises. Actually, they were trespassers. But the trouble is, there was no, at that time, legal authority to justify forcible eviction without going to court of law. The court struck down the action because the state was unable to point out any legal authority to justify forcible eviction without recourse of mode of law. The court was rightly not impressed by the state's fervent plea that the person who was forcibly evicted were rank trespassers and deserved no sympathy. I can tell you something on the case. The police official said, "साहब क्या कर रहे हैं? वो तो trespassers है. इन्होंने तो फेंकना चाहिए बाहर. हम लोग ने क्या खता किया? ना आपने गलत कुछ नहीं किया. कानून का है. कानून बताओ, बाद में फेंक दो." Then of course the Public Services Act was applied to the premises. There was another case where I was concerned that the Supreme Court enforced the rule of law in the case of Pakistani prisoners who had served their full term of imprisonment and not were under restraint under any other public safety law, but were just kept in jail by Indian authorities. So the stand of the government was that Pakistani authorities had meted out the same treatment to Indian prisoners. The court brushed aside that argument and observed that in India we enforce the rule of law which applies to citizens and non-citizens alike. All this may appear strange to some people and is certainly irksome to administrators. But as the price we have to pay for a democratic society based on the rule of law. And one test of your principles, of your belief in principles, is that we apply them to cases which we have no sympathy at all. Now, another important premise of the rule of law is that law shall be equal in its application. Thus, there is an essential link between the rule of law and the principle of equality. You heard the basic tenet of rule of law is articulated by the poet Thomas Fuller and adopted by the courts in the famous phrase, "However high you may be, the law is above you." Therefore, you may be the Prime Minister or the Speaker or the Imam or the Archbishop or the Shankaracharya or a judge or whoever. All are equally subject to the law of land because in our democratic polity, where the rule of law reigns, no one, however highly placed he may be, can claim immunity, much less absolute immunity from the law. According to our Supreme Court, the doctrine of equality before the law is a necessary corollary to the high concept of rule of law. What is the position when enacted law confers discretionary powers on public officials. At one time, under Dicey's pervasive influence, it was believed that wide discretionary powers were antithetical to the rule of law. But it was soon realized that discretionary powers are needed in administration, especially in implementation of socio-economic welfare measures. A play in the joints is required for effectuating socio-economic legislation. What rule of law frowns upon is the conferral of absolute unfettered discretion, not mere grant of discretion. Our Supreme Court, in the famous decision in Jaisinghani's case in 1967, ruled, and I quote, "The first essential of the rule of law upon which our whole constitutional system is based is that discretion, when conferred upon executive authorities, must be confined within clearly defined limits." The court reaffirmed this position and ruled in 1975 in Khuriram's case that in a government under law, there can be no such thing as unfettered, unreviewable discretion. The court referred to the famous statement of Justice Douglas of the Supreme Court that, and I quote, "Law has reached its finest moments when it has freed man from the unlimited discretion of some ruler. Absolute discretion is a ruthless monster. Wherever discretion is absolute, man has always suffered." Now, the concept of rule of law received an expansive interpretation. In this context, I'd like to refer to the view of the International Commission of Jurists. At its conference in New Delhi in 1959, it declared that the rule of law is not merely to safeguard and advance civil and political rights of the individual in a free society, but also to establish social, economic, education, and cultural conditions under which its legitimate aspirations and human dignity may be realized. Thus, rule of law is a dynamic concept which takes within its ambit all human rights which are indivisible and are independent. Now, the next question, a troublesome one, I want to talk about it. Does the concept of rule of law find its fulfillment by the mere enactment of a law? Or is it also concerned with the content and quality of the law? Enactment of a law is no doubt essential, but is that sufficient? Rule of law must not be confused with rule by law. Please make a note of that. Otherwise, rule of law will become an instrument of oppression and give legitimacy to laws grossly violative of basic human rights. The crux of the matter is that there is a certain core component without which a government cannot really be said to be based on the rule of law. What is that core component? The core component is respect for the basic human rights of the people and for human dignity. Otherwise, commission of atrocities and gross violation of human rights could be justified by merely pointing to the existence of a law. On this interpretation, rule of law would be purportedly justify racially discriminatory legislation of the kind which was enacted during the apartheid regime in South Africa, or the infliction of torture or cruel and inhuman punishment to a law which permitted it. So therefore the South African apartheid regime, so no, we are having rule of law. We have made a law. The question is, that is not enough. Rule of law, as I repeat, is not ruled by law. The horrific violations of human rights which happened in the large parts of Europe, which were under subjugation of the tyrannical Nazi regime, were perpetually pursuant to laws passed by the regime. We witnessed the midnight knock on the door, the mysterious disappearances, confessions extracted by torture, concentration camps, and the gas chambers. In Nazi Germany, the problem was not about lack of law. Most of the actions of the Nazi regime were pursuant to laws made by the regime. However, these laws are patently violative of human rights and, in my view, a formalistic, narrow concept of the rule of law which leads to this interpretation and consequences must be rejected. It is significant that the Universal Declaration of Human Rights, 1948, which Mrs. Eleanor described as the Magna Carta of mankind, declares in its preamble that it is essential that human rights should be protected by the rule of law. Andrew Lusser and Maurice Sunken, in their excellent treatise on public law, have aptly demonstrated, summarized the main ideas associated with the rule of law as follows. 1. Compliance with the law. Like citizens, government and public bodies must act in accordance with the law and must have legal authority for actions which impinge on the rights of others. That I've already covered in the previous cases. 2. The requirement of rationality. The rule of law implies rule by reason rather than arbitrary power or whim. In order to comply with the rule of law, decisions must be properly and logically reasoned in accordance with sound argument. And 3. The rule of law and fundamental rights. The rule of law requires the protection of the fundamental rights of citizens against government. Therefore, when we speak of law, it must satisfy at least the prerequisite that it guarantees the basic human rights and human dignity and ensures an implementation by due process through an independent judiciary exercising the power of judicial review. Absent these requirements, the rule of law would become a shallow slogan. In the memorable words of Lord Justice Stephen Sedley of the Court of Appeal in the UK, and I quote, "The irreducible content of the rule of law is a safety net of human rights protected by an independent legal system." I would like to stress that to enforce the rule of law, an independent judiciary is a must. India has been fortunate in having a judiciary which has, except for occasional aberrations, proved to be a good judicial sentinel and protected the human rights of the people. Without an independent judiciary, rule of law is meaningless and human rights are mere high-sounding moral platitudes. I would like to mention about the scourge of terrorism from which India has suffered. Over the years, culminating in the terrorist attack in Bombay, rather Mumbai, in November 19, 2008. Now there is no question that terrorism needs to be fought rigorously and relentlessly. However, anti-terrorist laws must not contain provisions which destroy or impact basic human rights. A law which permits killing of persons suspected to be terrorists, or which enables the indefinite detention in the absolute discretion of the executive, is destructive of the rule of law. Friends, fake encounters and encounter specialists have no place in a government professedly based on the rule of law. The purported justification that there is a great emergency to fight the war on terror overlooks the basic fact that the end does not justify the means. This was an article of faith with the father of our nation, Mahatma Gandhi. A state in any free democratic society cannot have recourse to measures which violate the very essence of the rule of law. I'd like to quote you the words of Justice Stevens of the US Supreme Court, because they also face this threat. If this nation is to remain true to its ideals, it must not wield the tools of terrorists, of tyrants, even to resist an assault by the forces of tyranny. And in this context, we should always remember the wise words of Justice Van Dyke, in his judgment in Olmsted versus the United States, and I quote, "Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites anarchy. To declare that in the administration of the criminal law, the end justifies the means is to declare that the government can commit crimes in order to secure the conviction of a supposed criminal. This would bring terrible retribution." But leave aside Supreme Court justice. Our own Supreme Court, in a celebrated decision in D.K. Basu, ruled that custodial violence, including torture and deaths in the lockups, strikes a blow at the rule of law, which demands that the powers of the executive should not only be derived from law, but also the same should be limited by law. Custodial violence is a matter of concern. It is aggravated by the fact that it is committed by persons who are supposed to be protectors of the citizens. It is committed under the shield of uniform and authority in the four walls of a police station or lockup, the victim being totally helpless. It cannot be said that a citizen sheds off his fundamental rights to life and liberty the moment a policeman arrests him. Nor can it be said that the right to life of a citizen can be put in abeyance on his arrest. If the functionaries of the government become lawbreakers, it is bound to breed contempt for law and would encourage lawlessness, and every man would have the tendency to become law unto himself, thereby leading to anarchy. No civilized nation can permit this to happen. The Supreme Court is the custodian and protector of the fundamental rights and the basic human rights of the citizens cannot wish away this problem. Next para is important. State terrorism is no answer to combat terrorism. State terrorism would only provide legitimacy to terrorism. This will be bad for the state, the country, and above all, to the rule of law. So please remember this, that rule of law, if you really believe in its principle, if you know what its essence is, it must be applied even in cases where we find this application difficult because we think, oh, there are terrorists or there are persons who are against the state, because you cannot abrogate the rule of law for the end of getting hold of a suspected terrorist. End does not justify the means, period. Now it must be remembered the rule of law is not a one-way traffic. It places restraints both on government and individuals. If the underlying principles of rule of law are to become a reality in governance, as also in the lives, no doubt it's necessary that they become a part of our lives, and law alone is not sufficient. In addition, fostering of the rule of law culture is imperative. The only true foundation on which the rule of law can rest is the willing acceptance by the people, unless it becomes part of their own way of life. Therefore, we would strive to instill the rule of law temperament, rule of law culture at home, in schools and colleges. We should strive for the universalization of its basic principles. Our effort should be to constantly aim at the expansion of the rule of law, to make it a dynamic concept which not only places restraints in exercise of official power, but facilitates and empowers progressive measures in the area of social economic rights of the people. That is indeed the moral imperative for the civilized world. You may well ask, why? Well, I can do no better than again recall the words of our great Justice Vivian Bose, who said, because we believe in human worth and dignity, because on analysis and reflection, it is the only way to live in peace and amity with our neighbors in this complex world, because it is the only sane way to live in an ordered society. I, for one, would eagerly look forward to the day when the quintessential principles of the rule of law, namely the protection and promotion of all human rights and human dignity of all human beings, is universally accepted. My ardent hope is that in a world torn by violent, sectarian and religious strife, rule of law with its capacious dynamic content becomes a secular religion of all nations based on tolerance and human respect. Well, one may say that is utopian. No doubt it is utopian. But please don't forget that progress is the realization of utopias. And let us resolve that we shall see to it that this utopia is not dismissed as something unreal. We shall strive for it, because it is in striving for it, we really strengthen, consolidate the principles of the rule of law, which is a way of life for all civilized nations and civilized people. I think I have talked enough, and I will thank you for your patience and listening to me with attention. And